1.5 hour session. And before moving to the session, I would like to brush up your knowledge on IP. Let me share my slides. Hope my slides are visible.
Yes, it's
Okay.
visible.
Yeah. Before going to the session, I would like to brief about the IP. So, what is IP? Anyone? There are so many students. Alina, Rekha. Anyone? You must have heard about this IP sessions, I think, more than 2 or 3 times in your college, right? So, IP is the word meaning is intellectual property. And there are some what statutes to protect these intellectual properties. So, what is actually intellectual property? It's all creations of mind, right? So we know that there are land, there is land, or just see this phone. All these are properties, but intellectual properties differ from these all these kind of property in some aspects, because intellectual property is not, it's not a tangible property. That means we cannot touch, we cannot feel it. So it's an intangible property. So different types of intellectual property are there. I think you must be knowing about patent, copyright, then GI, trademark, trade secrets, then Design Act. So all these are different statutes for protecting different kinds of IP. So we are giving patent for inventions, and we are giving copyright for literary and artistic work. And there are some other forms, that is trademark. What is trademark? Trademark is a special type of intellectual property which is used to distinguish the goods and services of one company from another company. And there is the Design Act. Design Act
I think the resource person is having some network issue. She will join soon.
Sorry, I lost my connection. Am I audible now?
Yes, yes, you are audible.
Sorry, I. Yeah. So designs are, we used to protect the aesthetic appearance of an article. Like, some designs, the Crocs shoes, there are some unique shape for this Crocs shoe. Or the shape of what? The Tupperware bottles. There are some unique shape. So that kind of designs we can register through design registration. And there are some other properties, intellectual property, that is GI. GI actually it is actually unique among all these intellectual property because it's a collective form of IP. Because in all other IP we are giving right to individuals, but in GI we are giving rights to a community. So what is GI? GI is a protection we are giving for some goods which is having some speciality because of the geographical location. For example, this Chendamangalam handloom or Pokali rice. So all these are some GIs of Kerala. So they have got some properties because of the geographical location. So we cannot say Pokali rice for some rice which is cultivating in some other area of Kerala. Like here in Pokali, we used to say it is cultivating in Ernakulam area and in Kadamakudi. And if it is cultivated in some other area, the same seeds, we cannot say it is a GI. So GI is the product itself having some qualities because of the geographical origin. Then there comes another intellectual property, that is protection of plant variety and Farmers' Right Act. So there, in India we cannot protect plant through patents. In foreign countries, that is in US, they are protecting plants through patents. But here we have adopted a sui generis system. That is, it's a law. We are protecting it through a new law, that is Plant Variety Act. So there we can register the farmer's variety. So that is also a intellectual property. Then the Semiconductor Design Act. So that is another form of IP. Then there is trade secret law, but it's not there in India under the statute. But there are in India we are protecting trade secret under contract law. Okay. So today I am here to giving you some insights about the patent filing process. So before moving to the session, we can just see the history of Indian patent law. So actually, the patent system itself evolved in 14th century in Venice. There they have given some protection. I think it's for 2 years for inventions. But in India, it's evolved in 1856 as the Act 6 on protection of invention based on the British Patent Law of 1852. So here in this law, they have given some exclusive privileges to inventors for a period of 14 years. So that is the initial form of our patent law. Then, sorry. Then the law again modified in all the years, and it's in 1883 it become Protection of Invention Act. In 88 it becomes the Invention and Design Act, and in 1911 there comes the Indian Patent and Design Act. And there, actually there are some landmark amendments in our patent law. And then it became to 7 years. Again, it changed to 14 years. And finally, in 2005, we have complied with the international agreement, that is TRIPS, and we have the patent protection for 20 years. And we have included so many other important sections in patent law on the 2005 amendment, and I'll discuss that in later. Okay, so this is a history of Indian patent system. So now we can go to the topic of today's topic, that is patent filing. So what is patent? Anyone? But I'll ask. and we are speaking, it's for this 1.5 hours, it will be very boring. So kindly talk. If anyone having the answer, you can talk. Okay. So patent is a statutory right for an invention which is granted for a limited period of time. So that is 20 years in India. Okay. So it's 20 years in India and it is a territorial right. And that right giving you some, that protection giving you some rights. So you can exclude others from making, using, selling, or importing the patented products, and it is a limited period of time. So how you'll get this right? So you have the invention with you. You have to give this to the Patent Office of India, and in return, they will give you the right. Okay. So you have to disclose your invention to. Then only they will give you the right. It's a patent certificate. So once you have got a patent, you will have a monopoly over others on your invention, right? So it's a monopoly. So why this patent is so important? So I'll tell you an example. You know, during COVID situation, it happened. We have we are in short of this drug. It's actually a bad side of patent because all these medicines are patented. Vaccines are not patented. I'll say that vaccines are not patented, but some vaccines are patented. That is, I think in Pfizer they have some patents, and the drugs which we have used during the COVID times, some anti-viral drugs. I think there's molnupiravir. All these drugs having some patents, and they have caused, it's caused higher amount, and it's a bad side of patent. So I'll tell you an example. Cancer patient. Cancer patient, there are some cancer, like breast cancer, HER positive breast cancer. For that patients, after chemo, they have to take one injection. That is, its name is Herceptin. And that injection, during its patent period, now it is off patent. During its patent period, that drug cost around 1,20,000 something rupees for one injection. And one has to take 14 such doses. So you can imagine the cost associated. So it's because of the patent. So all these pharmaceutical companies actually are making their profit out of this patent, their IP rights. So during COVID times, what happened was actually we have facility to make all these drugs, but we don't have the know-how to make all these drugs. We have to get the right from the patent owners, but we didn't got that patent till now. So we couldn't produce that drugs in India. Not drugs at all. It's like all the other medical devices and all. The importance of patents. And actually, so what we are talking right now is what is patent? Patent is an exclusive right given by the government of India in return in disclosing your invention to the government. So we right to discuss about the patent filing. So how to get a patent? Sorry, it's an exclusive right. So in order to get a patent, you have to we have to meet some conditions. Then only you get a patent. So what are those conditions? That is novelty, inventive step, and utility. So if an invention to be patented, it should be novel, it should be inventive, and it should have some utility. So I all these terms. And before that, we have to check whether it is falling for Indian Act. Because Section 3 and 4 of Indian Patent Act deals with some non-patentable subject matter. So already they have set some terms. There are some area which cannot be patented, which already it is there in the Act. So if it is something is falling under Section 3 and 4, it is not patentable. So we have to check first whether it is falling under the Section 3 and 4. Then we can say that it is not patentable. If it is not falling under 4, then we can go for this 3 test. That is whether it is having novelty, inventive step, and utility or industrial applicability. But it should have a it should be a useful invention. Otherwise, you won't get a patent. Okay. And when to apply for a patent? So you both are working on some invention. Just say some students. I'll say Devika and Riti. They both are working on some invention. They both are working with the same invention, and they both are planning to get a patent. So who will get the patent? Who is first approaching the patent office to file a patent? She will get the patent. So we have to file a patent at the earliest possible date, because the date is very important. We usually check actually the patent rights are territorial. Because if you are getting a patent, in India, you can enforce that patent only in India. It is not valid in US or any other country. It is valid only in India. But when we apply for a patent, we are checking the novelty of aspect of invention with a search, and we will search. We will conduct a search worldwide. So, if you are filing a patent today, whatever is there till yesterday is a prior of your invention. What all things are there in the iteration is a prior of your invention. So, and who can apply for a patent? So, according to Section 6 clause 1 of Indian Patent Act, they are saying that who can apply for a patent. So, by any person claiming to be the true and first inventor of the invention. So, any person who is an inventor, but he should be the true inventor. We cannot steal an invention and then we are going for a patent. And we are actually, we have to declare that I am the true and first owner of the invention. Actually, we are signing and giving an agreement with the patent office saying that I am the true and first owner of the invention. Then, if somebody is stealing your invention and going and filing it, in future, if you are finding out it, and we can sue them, because we are giving in writings, that is, I am the true and first inventor of the invention. And any person being the assignee of a person claiming to be the true and first inventor. So we can file a patent. If I am the inventor, I can file a patent. And any person being the assignee, that means if you are an inventor and you are planning to file a patent through a patent agent. Suppose I am a patent agent and you are approaching me to file a patent. So then you have to assign me to file my patent. That doesn't mean that you are assigning my right. You're assigning your right to me. You have to assign me to file the patent. So I'll file the patent on behalf of you. So I can be a person who can file a patent. Then a legal representative just who immediately before his death was selected to make such application, then his legal representative can file a patent. Okay. Then what can be patented? So I already said you that the inventions can be patented. Only inventions can be patented. And according to Section 2 Clause 1 Clause J of Indian Patent Act, invention means a new product or a process involving an inventive step and capable of industrial application. So this is the condition. I already told you that it is there are three conditions, that is novelty, inventive step, and utility. All these things are here. New product or process, that is novelty. Then involving an inventive step. Inventive step should be there. Then it should be useful. So this is what is invention according to the Act. So I'll describe this in detail. So this is according to the Act. It's a new product or a process involving an inventive step and capable of inventive. So what is inventive step? This is actually the most important criteria with respect to patentability. You know, all the patent applications, most of the patent applications filed at the Indian Patent Office is actually objecting condition. Actually, inventive step objection is always there in the FER. That is the first examination report. They will object your invention for lacking inventive step. So, inventive step means a feature of an invention that technical advance as compared to the existing knowledge, or having some economic significance, or both. So, there is a notion that actually in student community, or not in student community, everywhere actually IP is actually, you know, it's a completely new area now. All are getting awareness, but there is a notion that only you will get a patent only if you invented something new. That new means it's mean that it is totally a new thing, but patent modifications to existing knowledge. But you have to prove that there is a technical advancement compared to the existing knowledge, and or it should have some economic significance. So let's say I have invented something related to let's say a mouse. I'm using a mouse, the computer mouse. It's an input device. So I have invented a new mouse, which is having some additional keys, so I can control. Let's say I'm not I'm not a technician, but I'll say I'm making, and I am applying for a patent. So if somebody is working the same area, making this input devices, and they are saying that it is very obvious. It seems to be very obvious. I can make this invention very easily. Let's say Dr. Vineet, he was my colleague, and yeah, I like new type of gaming mouse. Yeah, new type of gaming mouse. So it's our inventions. So just me and Vineet, we were working together in a lab for. Yeah. So if I want to patent something related to my area, I have to prove that my invention has something, some technical advancement than what the Vineet is doing. Otherwise, I'll prove that my invention has some economic significance. That means, let's say I should prove that my invention is comparatively cost effective compared to Vineet's invention. So, in that way, we have to establish. We have to give proof. Then we can establish the inventive step. That means it should not be obvious to a person skilled in the art. Person skilled in the art means, let's say me and Vineet, we both are working in the same area. So I am applying for a patent, and Vineet is a person skilled in the art. So he is also working in the same area, and he is the person skilled in the art. So it should not be obvious to a person skilled in art. That means, so let's say Vinith is saying that I know this thing. If I am making some modifications here and there, I can make this invention. So if it is, so that's the case, it's not patentable. So we have to prove that it has some technical advancement compared to the existing knowledge. That's all about inventive step. Okay. And what is new invention? The criteria I've already told that is there are three criteria for patentability, that is novelty, inventive step, and utility. But in Indian Patent Act, they have not defined novelty. So instead they are given some definition on new invention. New invention means any invention or technology which has not been anticipated by any publication in any document or use before the date of filing of the patent application with complete specification. So, if you have to establish that your invention is novel, it should not be anticipated by publication. That means, just say you have invented something and you um, just say you invented some what waste disposal device, and you showed this to the panchayat that I have invented this, and this is working of this invention, and this is very useful for the this panchayat or this Muslim municipality. So now we are telling all these things to that person, and that person is actually interested in that invention, and he made a brochure, and he was planning to sell that particular waste, what was technology, as a product in that panchayat. And then you came to know that you can file for a patent, and then you have approaching the patent office for a patent. Then what is the problem? You already communicate with this invention with another person, and it is not even communicated. It is there in a published form. Or suppose you published your you published your work in a journal paper, and then you are approaching for a patent. Then also it is already in the public. So it all these things will kill the novelty of your invention. So new invention should not be anticipated by any public. Okay. Then, so what are non-inventions? I already told that there are section 3 and talks about the non-patentable inventions under Indian Patent Act. So it will differ into in different jurisdictions. In India, natural products are not patentable, but in US it is patentable. So it's differ from country to country, their patent law. So what are non-invention according to Indian Patent Act? These are all the non-patentable subject matter under Indian patent law. So you can see that invention which is frivolous or which is contrary to public order or morality, that means which is an immoral invention, it is not patentable. Or mere discovery of a scientific principle, it's not patentable. Then discovery of a new form of a non-substance, which is not. I'll say one thing here, that is a very important section under Indian Patent Act, and it actually made a lot of controversies world. This is section 3D under Indian Patent Act. That is, mere discovery of a new form of a non-substance is not patentable. What is, I told that this patent has a bad side. This pharmaceutical companies, what they are doing is they will invent some drugs, and they will patent it. And the patent protection is for 20 years. And by the end of 20th year, what they will do is they will make some modification drug. And they will patent, they will go for another patent. So in effect, what will happen? Protection for this particular drug will ever last. Okay, you understood that? Because there is a drug, and when the drug's patent life is going to expire, they will go for another patent. That means they will go for the new form of that substance. That means, let's say, if it is a acid form, they will go for a salt form. They will patent for a they will go for a patent for a salt form. Otherwise, they'll patent a. Otherwise, they will polymorph. Polymorphism is there, So they will patent this polymorph. Ineffectively, what will happen? They are actually protecting that particular molecule. So what happened? These drugs will be under protection for so many years. That means that actually in patent language they will say that evergreening of patent. Actually, that patent expired in 20th year, and they are actually getting another patent for the same molecule with some slight modifications. So India actually included this section to avoid this monopoly of pharmaceutical companies. It's actually created so many problems against India, but we actually inserted because this section, because since we are a developing nation and we cannot give such protection indefinitely for this kind of drugs. That this drugs are, it's actually, we have the right to health. The citizen have the right to health. So, and government has the obligation to provide the health. So, we have included this section under section 3. And it's so the new form of the non-substance is not patentable. And substance obtained by admixture of things. Just we are mixing something, just paracetamol and cetirizine we are mixing, and we are making another drug, and we cannot patent it because it's just two things, and they are working independently, and there is no synergism. It is not patentable. If there is a synergism, we can go for a patent. Then mere arrangement or rearrangement of things. Let's say a mouse with a Wi-Fi. Mouse was already there and Wi-Fi was already there, and we are assembling together. There is no activity. Just both they are working independently. Okay. Or pen with the torch. Pen is doing the writing job and torch is giving the light. So both they are working independently. So that such inventions are not patentable. The method of treatment is not patentable under Indian Patent Act. That means treatment methods, in diagnostic methods, all these things are not patentable. Then plants and animals, all parts thereof are not patentable. So we cannot patent natural things. So plants, we cannot patent plants, we cannot patent animal parts, but we can patent genetically modified organisms. Okay. Then we cannot patent all these things, literary, dramatic work, then presentation of information, topography of integrated circuits, and which is invention, which is traditional knowledge. We cannot patent traditional knowledge. And there are some inventions like atomic energy inventions are not patentable. And if you are satisfied all these conditions, and if you are ready to file a patent, so where to apply for a patent? So we have 4 patent offices in different jurisdictions, and Mumbai, Delhi, Chennai, and Kolkata. And Kolkata is the head office, and all these other things are other offices are branch offices, and our territory is come under Chennai. So we have to file our patent in Chennai patent office. We cannot file any other patent office. Since we are residing in Kerala, we have to file in Chennai. Okay. So how many types of applications are there? So we have different types of patent applications. So one is ordinary application. So ordinary application means it's a normal application. We are filing directly at the Indian Patent Office. That is a normal patent application. That is ordinary application. Okay. Then there comes application and patent of addition. So what is divisional application? Divisional application means you have filed, you are drafted a patent document and you are filing with the patent office, and the controller finds that there are one more invention is there, which is not actually we can patent only one inventive concept or one invention, one patent for one invention. So if there is more than one invention, we have to divide that application. So controller feels that it has one more inventive concept. So then you have to divide that application and you have to file. And then that kind of patent application is known as divisional application. Okay. So it is divided out of your parent application. So the first one is called parent application, is called daughter application. That is divisional application. Then so I think I lost my connection again. Am I audible?
Yes,
Am
yes,
I audible?
yes,
Okay,
yes.
sorry.
Yes, yes.
So patent of addition means, so we have invented something and we got a patent, and after some years we feel that we have to make some modification in the same invention. So there is a slight modification in the other invention. I have to get a protection in that slight modification. So what we can do is, if you are filing it as a separate application, what will happen? The earlier invention, what you have already filed and you have got a patent, that invention will act as a right, because they will check the novelty. So then they'll feel that this is a slight modification of this earlier invention. So in that case, you can apply for a patent of addition. That means you can file it as a patent of addition. Then they will not consider your earlier invention as a prior art for your subsequent invention. So that's a benefit. But the problem is, if you file first application in 2000 and you are filing the second application in 2005. So the first application you filed in 2000 and you got patent for that, and it will have a term of 20 years. That means it will expire in 2020. And the other patent of application you have filed in 2005, it will also have an expiry date at 2020. That means it will end with the parent application. So that means that invention has got only years of protection, because it is an patent of addition. And there is one more benefit is there, because you have to pay only one renewal fee for both the patent, and it ends with the main patent. Okay, so that is patent of addition. And there comes the two types of another application, that is convention application and PCT application. Convention application and PCT applications, that they both are foreign filing mechanisms. So somebody is want to pursue their invention in foreign countries also. They filed a patent in India and they want to pursue their invention in a foreign country. So in that case, you can pursue any of this way, that is convention application or PCT application. Convention application means first you have to file in India and you have to file a foreign application within 12 months from the first filing. So you'll get this 12 months time to decide in which country we want to file a patent application. That is convention application. There comes the PCT application. That is actually it's a most popular way of filing foreign application. This is only a filing mechanism, not a patent granting mechanism. It is only a patent filing mechanism. You know, you have to file in India, and within 12 months you have to file a PCT application. That means PCT application means Patent Cooperation Treaty application. Patent Cooperation Treaty, actually it is a treaty. Actually, there is 154 countries are signatory to this treaty, and you can file in a single language. And you know, if you want to file in Japan or China, you have to file in their local when you want to file in Japan or Korea, or because they want your application in English. You have to file the application in language. That is very difficult. But in PCT system, you can file a patent in either Hindi or English. You will get a 31 months time. India, it is 31 months. In different countries, it's 31 months is differ actually. So in India, it is 31 month time. So you have to decide in 31 month time in which all national country, which all country you have to file your patent. So first you're filing in India, then 12 months you have to file a PCT application. Either you can wait 12 months or you can directly file a PCT application. And you will get the 31 months time. That means till the 31 months time, you will have the priority. So if anybody is filing after this first filing date, that is 0 months, that means suppose you filed a PCT application in 2000 January 1st. So if anybody is filing after that, won't get the priority. You will be having the priority. So you will have 31 months time to decide in which all countries you have to pursue your invention. So in 31 months time, you have to enter the national phase. Then there you can say if you want to file in China, Korea, then then they will accordingly they will examine your application, and this is the process. So both these things are foreign filing systems. Okay. Then provisional and complete application. If you know you are working on something and you want to file a patent, but you feel that you have to get some more time to complete your invention. Just have some idea and you have worked something, but you have to you need some more time to complete your invention. But you feel that if you are not filing a patent, if somebody else will go and file a patent for the same invention. You have a feeling that it is a potential area. If somebody else has filed before you, you lost the chance. So you can you can file a provisional application. What is provisional application? You know the provisional certificate. We all will have a provisional certificate. So provisional certificate will have the validity till you will get the complete your your original certificate. So here like that you have to file a provisional application. So you have 12 months time to fully develop your invention. Okay, and then you can file for the complete application. So you will get a priority date there. That is provisional and complete application. So then now we can move on to the patent filing process. So what all things happen once you file a patent? So before filing, you have to check whether all these conditions, so whether it is having novelty, inventive step, and utility. And if all these conditions are satisfied, you have to draft the patent. Actually, patent is usually called a techno-legal document. So it's have some legal language. So you have to draft a patent according to the requirement. There are some statutory requirement under Indian Patent Act. So you have this, the invention should be filed at the patent office in a particular manner. Okay, you have to give a title, you have to give some claims, you have to give the detailed description of, you have to give an abstract, you have to give the drawings, then you have to give working examples for your invention. All these things should be there. It does not, it like you must be knowing the structure of a journal publication, but it's not like that. It's totally different from a journal publication. You have to give in a particular way. That is it's a techno-legal document. So after this, you have to draft all these things and then you can file at the patent office. So if you file a patent application at the patent office, what will happen after the filing? So if first you file the patent at the patent office, and they will keep your invention for 18 months secretly. It will be there with the patent office. They won't disclose to anyone till 18 months. And after 18 months, what they will do? Publish the application. Okay? So that is a normal procedure. But there is another way, that is an early publication is permissible. Early publication comes when you want to fast track your application. You need to grant your patent in a shortest period. So then you can follow a fast track way. So in that case, you have to file a request for expedited examination and an early publication. So what they will do is, when you file a request for expedited examination and early publication, they will publish your application within 1 month. You filed a patent application and you filed an early publication request. So what they will do? They will publish your application within 1 month. Okay. In normal procedure, it will publish within 18 months. But in expedited manner, it will publish within 1 month. So after publication, what will happen? The patent office will examine your application. If you have made a request for examination, you have 48 months from the priority date to make a request for examination. That is a normal way. Expedited way, you have to file whenever you want. Okay. But in a normal course of time, 48 months from the priority date, the earliest filing date, you have 48 months time. Within that time, you can file a request for examination. But practically what is happening is that we usually file a request for examination with the filing itself. Otherwise, what will happen? If you are waiting for 48 months to file a request for examination, 48 months means 4 years. So at the end of the 4th year, you are filing a request for examination, and then only they will examine your patent. So it will take a long time to grant a patent. So to avoid that, we used to file a request for examination along with the patent filing. Okay. Then what will they do? If you are not filed a request for examination, if you are not filing a request for examination after the expiration of the 48th month, they will consider this as an abandoned application. They won't pursue this application further. So, if you filed a request for examination, they will examine your application. So, what they will examine? They will examine whether it has all these criteria. I have already told these criteria. Whether it is falling under section 3 and 4, or it is having novelty, or it is having inventive step, or it is having utility. All these things they will check. They will check all these criteria and they will give you a report. So in that report, they will say that there is a prior art, which is a patent document or a journal article, because of this journal article, in this journal article, there are some disclosure about this invention. So it is not novel. Otherwise, they will say that based on these 2 or 3 paragraphs, this invention is lacking inventive step. So they will give you such a report. So like we used to get this review comments from the journal editors. So like that, they will give you a examination report. So then you will have 6 months time to respond to that examination report. 6 months time is there to respond to that examination report. If you are not able to reply in 6 months, you can extend that time in form 4. You have to file a form 4, then they will extend the time to 3 more. You have to file a reply within 9 months at the max. And once you submitted a response, they will examine your response. And if they are not satisfied. Otherwise, they will satisfied. If they are satisfied with the response, they will grant the patent. And if they are not satisfied with the response, they will examine your patent. Otherwise, nowadays what they are doing is they will call you for a hearing. It's all, it's kind of a court procedure, civil court procedure. The controller have the power of, according to section 77, he is having a power of civil court. So they will call you for through an agent. You don't need to go for the hearing. Otherwise, you have to go for the hearing and you have to say that because of this reason, my invention is novel. This reason, my invention is inventive. So we say that like the court procedure. Okay, if they are satisfied with the hearing, they will grant the patent. Otherwise, they will refuse it. That is the one way. And after the because everyone should know that as a patent application is granted for this invention by this inventor or by this applicant. So the such and such invention is patented. So why we are publishing that? Because there is an opportunity. There are 2 publications. One is before grant, one is after grant. Like that. So if somebody is getting a patent without satisfying all these conditions, we can oppose it. So there is 2 types of opposition, that is pre-grant opposition and post-grant opposition. Pre-grant opposition means which is before the grant. So which is happening after the publication, 18 months publication. So then you can go for the opposition. So we can say that if somebody is still stalled your invention, trying to get a patent, then you can approach the court or approach the controller, that you can say that it is my invention and they have actually steal my invention. And then there is the post-grant opposition. What is post-grant opposition? It is after the grant. So then you missed during the time of 18th month publication. You only saw that patent only in the post-grant publication. Then you can go for opposition. So then there are many procedure for that. There are so many criteria to revoke a patent. So if it is not an invention according to the Indian Patent Act, and it is if it is a stolen invention, then you can revoke that particular invention. Okay, so this is the normal process of patent filing in India. Okay, then the forms for filing. So there are some forms. If you want to file a patent, you have to file these forms along with the application. So form 1 is the application form. containing all the general details, like not the technical details, like the applicant name, inventor name, and title of the invention, and you have to give the address. All these things. All these things come under in the Form 1. That is the general details of the invention. And Form 2 is the technical details. It will contain the technical details of the invention. There you have to disclose all the invention details. So you have to give a title. You have to give a statement of the invention. There is an objective of the invention, then field of the invention, then background. You have to give the background, then the summary, then the detailed description of the invention, then examples if you are giving working examples, like you have invented something on some chemical invention, and you have to give some examples for that particular reaction or something like that, and all these things are there. Then Form 3, the statement of foreign filing under Section 8. So there you have to give, if you want to pursue your invention in foreign countries, you have to give a statement under in Form 3. Otherwise, you can't file a patent in foreign countries. If you want to file a patent without filing in India in a foreign country, there is an option. That is, if you're there is a rule, not rule actually, in Section 39 deals with the foreign application of Indian citizens. If you're not Indian citizen, which is a person who is residing in India, he has to file a patent in a foreign country without filing in India. Then he has to take a permission from the controller. Otherwise, he cannot file a patent directly in a foreign country. So you have to take a permission from controller in Form 25. Then you can file a foreign application without filing in India. That is another situation. So in this case, if you want to file a if you are filing an Indian application, and with that you have to give a statement of foreign filing with the normal application. Then Form 18, that is a request for examination. I told you that you will have 48 months time from the filing date to file the request for examination. But you can file, either you can file along with the application filing or with the 48 months. So that is there. Then Form 5, that is declaration as to inventorship. That means you have to declare that I am the true and first inventor of this invention. That is in Form 5. So with every application, you have to give this form also. Then Form 9, if it is required, if you want to fast track your application, you have to file Form 9 and Form 18. Then Form 26. What is Form 26? Form 26 is if somebody is you have assigned someone to file your applications. So you have to give a power of authority to that person. So that is in Form 26. So these are all about the forms and patent filing. So any doubt? All these things are clear to everyone? Okay. So this is the official fee. Yeah, somebody was asking if it's costly or no. So it's definitely costly because all these costs are, you have to give in installments, like installment. The first you have to file for a patent, then you have to pay this much fee. That is, for an actual person, it is 1,600, and educational institution also having the same fee. Or if it is a company or something like that, you have to pay 8,000 rupees for filing. And for request for examination, it is 4,000. And for companies, it is 20,000. Actually, all these things are, all these fees are, for physical filing. For physical filing, the fee is 10% higher. And for expedited examination, it is 8,000 for education institutions and national persons. 60,000 for others, the companies and the research institutes and all. And for only publication, it is 2,500 and 2,500. And annuity, once you have got a patent, you have to maintain that patent. If you want to maintain the patent, you have to pay the annuity fee. So annuity is you have to pay from the third year onwards. So the first year it is around it is 800, and the 20th year it will become 8,000. So you have to pay the annuity in every year, or till the year if you want to till the year you want to pursue that invention or protect that invention. That's the annuity. Okay. So this is all about the official fee. If you are, if you are for approaching a law firm or a patent agent to file your patent, you have to pay their professional fee also. So in that way, patent is very costly. Okay. So when you want to when you want to file a patent, or when you wish to file a patent, you should think about it, whether this patent should have some commercial potential or not. Otherwise, you cannot afford this cost. If you are able to afford this cost, you can definitely go for filing for this patent. Okay. So that's all about patent filing. So now I would like to talk about my center, that is India University Center for IPR Studies, which is in Cochin University, and we are actually an autonomous center in Cochin University under state government, and actually the Honorable Minister Pinarayi Vijayan is the council chairman. So we are having three courses. One is in PhD program, and one is the 1 year LLM. And PhD, there is two programs, LLM and LLM IPR PhD. LLM IP PhD is for non-law students. LLM IPR PhD is for law students. So non-law students was passed uh, this any science subject or any engineering subject, you can go for this course, and it is a 5 year course. You will get LLM degree as well as a PhD degree in IPR. Okay. So then there is a 1 year LLM course, that is now it is 2 year from this year onwards. So there it is exclusively for law students. And there comes I would like to sorry tell about some facilities at our center. So we have IP advisory services. So whenever you want to clarify your we actually all of our faculties are working with IP. So you can contact us at any time. I'll give you the contact mail IDs and phone numbers. So any IP related matters, you can mail to that particular mail ID, and it is free of cost. And we are actually filing patents for the state universities in Kerala, and it is actually free of cost. So for universities, we are actually funding for them to file the patent, and we will fund them till the grant. So after the grant, they have to maintain the patent. Till the grant, we will fund them. And for individuals and local inventors, we are having a consultancy. So you can file your patents through the consultancy. And we have some faculties which is actually working with geographical indicated goods. Dr. Anderson is there. He is working with, actually his PhD is in geographical indication. And he is actually working with the marketing of the geographically indicated goods of Kerala. Right now, we have conducted this for two products, that is Pokali rice and Chendamangalam Halum. So we have created this e-commerce website, and we have helped them to, to some stalls in the international airport, Nedumasheri. And we have started the consultancy for complete application for invention from outside university, that is for the local inventors, which is in place from 2021 onwards. And this is our fee. That is, for a novelty search, if you want to conduct a novelty search, whether you want to know that whether your invention is having some potential to patent, then you can approach us for this service, that is novelty search. We'll do at a cost that is 5,000 per project, and novelty search for micro and small medium scale industries, it is 7,500, and this is the rate. And all other services also there, like is you can file a complete patent application or complete after provisional application, then request for examination and response. All these things we'll do, and this is the cost associated. And this is the details of patents which are filed through our center. Actually, we facilitated this filings of these patents, and we have filed around 32 patents and one in US, and which is actually 35 out of which 25 patents for CUSAT, and for Kerala we have filed only one. For Calicut also we have filed only one, and Kannur University we have filed out of which one is US application, and for Calicut 8 patents were granted and one in US. Okay, this is statistics. So that's all about my presentation. So if you have any queries, we can discuss that.
Asha, I think there's a question in the chat box. How do you identify a GI?
Sorry,
How do you identify a GI?
I did.
Yeah, ma'am. How can you identify a GI? Say, Pokali rice was not a GI before it was being filed for a GI, right? So, how do you? Who is behind identifying geographical indications? If I have an invention, then I am interested in filing a patent for that because it's my invention. I need to protect. But for a collective thing, a collective innovation, who is interested in finding and proceeding with that? How is it done?
It's a very good question, actually. In GI, there is a of India. It's not with the patent office. It's a different entity. So there's the GI registry is there. In collective forms of IP, it's a different and it's actually a gray area. That is, a lot of people are working with that. If you have somebody has to take an initiative to identify a GI. In the case of Pokali rice, I know personally that person who is cultivating this Pokali rice, and they are not aware of all these things. All these farmers or this community, they won't be aware of all these things. So somebody has to take an initiative, or government has taken initiative to identify a GI. So, in the case of this Aramula mirror, in that case also they have actually, the person who has taken here in Pokali rice, person who is taking care of all these things. So we used to meet that person only. He's in Ramati. So somebody has taken initiative and he has to identify, and we have to prove that it is a GI. So there is some criteria, but I'm not aware of the criteria because I'm only dealing with this patent. So there is some criteria. So you have to file in that particular forms, and we have to prove them that this product have some quality according to these criteria. So we have to prove that, like in farmers variety, you have to prove them for 3 years. We have to prove them that this for particular variety is showing this qualities. So like that, you have to prove GI registry that this product has this qualities because of this job. Am I audible?
Yes, you are.
Yeah, it is breaking. Yeah, now it's audible.
Hello?
Madam, there is another question. Patent violate ചെയ്താൽ എന്ത് പറ്റും?
Sorry?
There is a question in the chat box. Patent violate ചെയ്താൽ എന്ത് സംഭവിക്കും? എന്ത് പറ്റും?
Yeah. അപ്പോൾ പേറ്റന്റ് വയലേറ്റ് ചെയ്യാന്ന് വെച്ചാൽ ഇൻ ലീഗൽ ലാംഗ്വേജ് അത് ഇൻഫ്രിഞ്ച്മെന്റ് എന്ന് പറയും. എന്ന് വെച്ചാൽ എനിക്ക് മനസ്സിലായതാണ് പേറ്റന്റ് വയലേറ്റ് ചെയ്യുന്ന വെച്ചാൽ ഒരാളുടെ പേറ്റന്റ് ഉപയോഗിച്ച് നമ്മൾ അയാളുടെ പേറ്റന്റ് റൈറ്റ് വെച്ചിട്ട് നമ്മൾ ഒരു ഇൻവെൻഷൻ നമ്മൾ തന്നെ ഉണ്ടാക്കുന്നു. അതായിരിക്കും ഉദ്ദേശിക്കുന്നത്. അക്ഷയ അങ്ങനെയല്ല ഉദ്ദേശിച്ചത്, ഞാൻ അങ്ങനെ വിചാരിക്കുന്നു. അപ്പം ഒരു ഇൻവെൻഷൻ വി ഹാവ് യൂസ് ദാറ്റ് ഇൻവെൻഷൻ ടു മേക്ക് എ പ്രോഡക്റ്റ്. ഒരു പേറ്റന്റ് റൈറ്റ് ഉള്ള പ്രോഡക്റ്റിന് നമ്മൾ യൂസ് ചെയ്യുന്നു. എന്തിനും ഒരു പ്രോഡക്റ്റ് ഉണ്ടാക്കാനായിട്ട്. ദാറ്റ് ഇസ് വയലേഷൻ. So in legal language, it's called infringement. So there are some procedure. If you are if you are as a patentee, there are procedure. That court procedure is there. They will sue you because in Apple and Samsung, you must heard about that case because they have sued. I think Samsung sued Apple for this design. I think that central button. So it's actually they are sued for billions of rupees, billions of dollars actually. So there are some procedures. If you are violating a patent, this person can go to the court. They have to prove that this person has infringed my patent. Then there is some court procedure. There is civil procedure and criminal procedure is also there. So either you have to pay the fine or you have to get an imprisonment. Is it clear? ഫിനാൻഷ്യൽ ബെനിഫിറ്റ് എങ്ങനെയാണ് കിട്ടുന്നത്? യാ, ഇപ്പൊ നമ്മൾക്കൊരു ഇൻവെൻഷൻ ഉണ്ട്. അപ്പൊ നമ്മൾ ഇൻവെൻഷൻ പേറ്റന്റ് കിട്ടിയെന്ന് പറഞ്ഞാൽ നമുക്ക് ഒരു ഫിനാൻഷ്യൽ ബെനിഫിറ്റും കിട്ടൂല. ഓക്കെ, പേറ്റന്റ് ഉണ്ട് എന്ന് വെച്ചിട്ട് ഒരു ഫിനാൻഷ്യൽ ബെനിഫിറ്റും ഇല്ല. പക്ഷെ നമ്മൾ ആ പേറ്റന്റ് വെച്ചിട്ട് നമ്മളൊരു പ്രോഡക്റ്റ് ഉണ്ടാക്കണം. ഞാൻ പറയുകയാണ് ഇപ്പൊ ഈ മരുന്നിന്റെ കേസിലാണ് പ്രോഫിറ്റ് അവർ ഉണ്ടാക്കുന്നത്, അല്ലെങ്കിൽ ഈ ഇലക്ട്രോണിക്സിൽ അവർ ഏറ്റവും കൂടുതൽ പ്രോഫിറ്റ് ഉണ്ടാക്കുന്നത് അങ്ങനെയാണ്. ഇപ്പോ എന്താ പറയാ, ഐഫോണിന്റെ ഡിസൈൻ വന്നത്, ആ ഒരു സെൻട്രൽ ബട്ടൺ ഡിസൈൻ എന്ന് പറയുന്നത് യൂണിക്കാണ്. അപ്പൊ ആ ഡിസൈൻ ഒരു IP ആണ്, അത് അവർ രജിസ്റ്റർ ചെയ്തിരിക്കുകയാണ്. അപ്പൊ ആ ഒരു ഡിസൈൻ രജിസ്റ്റർ ചെയ്ത് വെച്ചിട്ട് അവർ പ്രോഡക്ട്സ് ഇറക്കുകയാണ്. എന്താ വെച്ചാൽ അവർ പ്രൊട്ടക്ഷൻ ഉണ്ട്, അവർക്ക് ആ ഒരു പർട്ടിക്കുലർ ഇൻവെൻഷൻ അവർക്ക് പ്രൊട്ടക്ഷൻ ഉണ്ട്. അപ്പൊ എന്താ സംഭവിക്കുന്നത്, അവർക്ക് മാത്രമേ ആ പർട്ടിക്കുലർ പ്രോഡക്റ്റ് മാർക്കറ്റിൽ ഇറക്കാൻ പറ്റുള്ളൂ. ബ്രേക്ക് ത്രൂ ആണെങ്കിൽ ഭയങ്കര പോപ്പുലറായി, അപ്പൊ എന്ത് സംഭവിക്കും, നമുക്ക് അതിൽ നിന്നുള്ള ബെനിഫിറ്റുകൾ. സോ അത് കമ്പനീസിന് അതേ സെയിം സാധനം കൊണ്ടുവരാൻ പറ്റില്ല. വൈ? സെയിം ഡിസൈൻ ഇസ് ഓൾറെഡി പ്രൊട്ടക്റ്റഡ് അണ്ടർ അവർ their ID for Apple's IP. So we cannot. So if you are planning to infringe them, they will sue you. So in that way, you will get a benefit. So otherwise, you had an invention, you got a patent, നിങ്ങൾക്ക് പേറ്റന്റ് ഉണ്ട്, പക്ഷെ നിങ്ങൾക്ക് അത് വർക്ക് ചെയ്യാൻ താല്പര്യമില്ല, നിങ്ങൾക്ക് അതിനുള്ള നമുക്ക് പൈസ ഒന്നുമില്ല. അപ്പൊ നമുക്ക് എന്ത് ചെയ്യാം? We can approach a company, you can give the rights to them and they will make the products out of your patent and you can have some agreement with us company. നിങ്ങളൊരു എഗ്രിമെന്റിൽ വരണം. എന്താണ്, ഞാൻ എന്റെ ഇൻവെൻഷൻ തരാം, നിങ്ങൾ പ്രോഡക്റ്റ് ഉണ്ടാക്കാം, അപ്പോൾ ഇതിന്റെ ഒരു പ്രോഫിറ്റിന്റെ ഇത്ര % എനിക്ക് തരണം. ആ ഒരു റൈറ്റ്, ആ ഒരു എഗ്രിമെന്റിന് മേൽ നിങ്ങൾക്ക് ആ അപ്പൊ എന്ത് സംഭവിക്കും, നിങ്ങൾ അതിനുള്ള ബെനിഫിറ്റ് കിട്ടും. Am I audible?
Yes, yes.
I think I again lost my connection.
Yes, now it is
Sorry.
audible.
Yeah. സോ ആ ഒരു രീതിയിൽ ഒരു എഗ്രിമെന്റ് പുറത്ത് നമുക്ക് എന്ത് ചെയ്യാം, നമ്മുടെ ഇൻവെൻഷൻ ഒരാൾക്ക് അസൈൻ ചെയ്യാം. അപ്പൊ അതിലും നമുക്ക് ഇൻകം ഉണ്ടാകും. പക്ഷേ ഞാൻ പറയുന്നത് വെച്ചാൽ ഒരിക്കലും നമ്മൾ ഒരു കൊമേഴ്ഷ്യൽ പൊട്ടൻഷ്യൽ ഇല്ലാത്തൊരു സാധനത്തിനെ കൊണ്ടുപോയി പേറ്റന്റ് ചെയ്യാൻ നോക്കരുത്. കാരണം എപ്പോഴാണ് നമുക്ക് പിടിവീഴെന്ന് പറയാൻ പറ്റില്ല. ഇപ്പം ആക്ച്വലി ഇന്ത്യൻ പേറ്റന്റ് ഓഫീസ് എപ്പോഴും നമ്മൾ പേറ്റന്റ് എടുത്തു കഴിഞ്ഞാൽ കൂടി അവര് ഇയർലി ഒരു വർക്കിംഗ് സ്റ്റേറ്റ്മെന്റ് ചോദിക്കുന്നുണ്ട്, നമ്മൾ ഈ പേറ്റന്റ് വർക്ക് ചെയ്തോ ഇല്ലയോ എന്നുള്ളത്. അക്കോർഡിംഗ് ടു ഇന്ത്യൻ പേറ്റന്റ് ആക്ട് നമ്മളൊരു ഇൻവെൻഷൻ എടുക്കുകയാണെങ്കിൽ, ഇൻവെൻഷന് പ്രൊട്ടക്ഷൻ എടുക്കുകയാണെങ്കിൽ വി ഷുഡ് വർക്ക് ഓൺ ദാറ്റ്, അതർവൈസ് ഇറ്റ്സ് അഗൈൻസ്റ്റ് ദ ആക്ട്. അപ്പൊ നമ്മളത് വർക്ക് ചെയ്യുന്നുണ്ടോ ഇല്ലയോ എന്നുള്ളത് നമ്മൾ പേറ്റന്റ് ഓഫീസിൽ നമ്മൾ ടൈംലി നമ്മൾ അറിയിച്ചിരിക്കണം. ഇയർലി നമുക്കൊരു റിപ്പോർട്ട് കൊടുക്കാറുണ്ട്. അപ്പൊ അതുകൊണ്ട് പേറ്റന്റ് എടുക്കുമ്പോൾ നമ്മൾ വളരെ കെയർഫുൾ ആയിരിക്കണം. ഓക്കെ, ഇനി എന്തെങ്കിലും ക്വസ്റ്റ്യൻസ് ഉണ്ടോ? പേറ്റന്റ് ചീറ്റിംഗ് വഴി കിട്ടിയതിനെ പ്രൂവ് ആയാൽ പണിഷ്മെന്റ് കിട്ടുമോ? പണിഷ്മെന്റ് ഉണ്ട്. നമ്മൾ പേറ്റന്റ് ചീറ്റിംഗ് എന്ന് വെച്ചാൽ ഇൻഫ്രിഞ്ച്മെന്റ് അല്ലേ, പണിഷ്മെന്റ് ഉണ്ട്. യു ഹാവ് ടു പേ ദ ഫൈൻ. എന്തായാലും ഞാൻ പറഞ്ഞില്ലേ, എല്ലാ കമ്പനീസും ആക്ച്വലി എല്ലാ കമ്പനീസിനും വലിയ വലിയ മൾട്ടിനാഷണൽ കമ്പനീസിനും എല്ലാം ഒരു എന്താ പറയാ IP ടീം ഉണ്ടാവും. അവർ ചെയ്യുന്നതെന്ന് വെച്ചാൽ അവരിങ്ങനെ നോക്കിയിരിക്കും എവിടൊക്കെ എന്തെങ്കിലും പേറ്റന്റ് ആരെങ്കിലും നമ്മുടെ ഇൻഫ്രിഞ്ച് ചെയ്യുന്നുണ്ടോ ഇല്ലയോ. അതല്ല എന്തെങ്കിലും എന്താ പറയാ ഒരു പർട്ടിക്കുലർ പേറ്റന്റ് അവര് അത് വെച്ചിട്ടാണ് അവർക്ക് തോന്നുകയാണ് നമ്മുടെ ഇൻവെൻഷനെ പോലെ തന്നെ ഉണ്ടെന്ന് തോന്നിയാൽ തന്നെ അവർ എന്ത് ചെയ്യും, ഉടനെ സ്യൂ ചെയ്യാൻ ഇറങ്ങും. അതൊരു പ്രാക്ടീസ് ആണ് ആക്ച്വലി, അവർക്കൊരു ഇൻകം ജനറേഷൻ ആക്ച്വലി. ബില്യൺസ് ഡോളേഴ്സിലാണ് അവർ സ്യൂ ചെയ്യുന്നത്. മിക്കവാറും വലിയ വലിയ കമ്പനീസ്, സാംസങ്, ആപ്പിൾ പോലുള്ള കമ്പനികൾ അല്ലെങ്കിൽ ഫാർമസ്യൂട്ടിക്കൽ കമ്പനീസിന്റെ ഒക്കെ ഒരു ഇൻകം ജനറേഷൻ വേ ആണ് ഈ പേറ്റന്റ് ഇൻഫ്രിഞ്ച്മെന്റ് സ്യൂട്ട്സ് ഫയൽ ചെയ്യുക എന്നുള്ളത്. Patent modification is possible. Yeah. ഞാൻ പറഞ്ഞില്ലേ, patent modification in the sense if you can modify on already existing things. But if it is a slight modification, and if there is a patent and if it is a slight modification, you have to prove that this is an entirely different inventive concept and it is having some economic significance and utility and technical advancement. എന്ന് വെച്ചാൽ നമ്മൾ ഓൾറെഡി ദർ ഇസ് അൻ ഇൻവെൻഷൻ, ആ ഇൻവെൻഷൻ വെച്ചിട്ട് അതിൻ്റെ ഒരു സ്ലൈറ്റ് മോഡിഫിക്കേഷൻ ആണ് ഇപ്പോ. അപ്പം ആ ഒരു പർട്ടിക്കുലർ ഇൻവെൻഷനെ അത് നമ്മുടെ തന്നെ ഇൻവെൻഷൻ ആണെങ്കിൽ വി ഹാവ് എ ഓപ്ഷൻ, ദാറ്റ് ഈസ് പേറ്റന്റ് ഓഫ് അഡിഷൻ. ദ ഫസ്റ്റ് ഇൻവെൻഷൻ നമ്മുടേതാണ്, നമ്മൾ മോഡിഫൈ ചെയ്യാൻ പോകുന്നത് നമ്മുടെ തന്നെ ഇൻവെൻഷൻ ആണെങ്കിൽ അത് പ്രശ്നമൊന്നുമില്ല, നമുക്ക് പേറ്റന്റ് ഓഫ് അഡിഷൻ വഴി പ്രൊട്ടക്ട് ചെയ്യാം. അതല്ല, ഇറ്റ്സ് ഓൾറെഡി എൻ എക്സിസ്റ്റിംഗ് പേറ്റന്റിന്റെ മോഡിഫിക്കേഷൻ ആണ്, ഓൾറെഡി എക്സിസ്റ്റിംഗ് ഇൻവെൻഷന്റെ മോഡിഫിക്കേഷൻ ആണ് നമ്മൾ പേറ്റന്റിനെ ഉദ്ദേശിക്കുന്നതെങ്കിൽ വി ഹാവ് ടു പ്രൂവ് ദാറ്റ് ദിസ് ഇസ് എ ടോട്ടലി എ ന്യൂ ഇൻവെന്റീവ് കൺസെപ്റ്റ്. ഇതിൽ നിന്നൊരു ഡിഫറെന്റ് ആയുള്ള കൺസെപ്റ്റ് ആണ് എന്ന് നമ്മൾ പ്രൂവ് ചെയ്യേണ്ടി വരും. അല്ലെങ്കിൽ നമ്മൾ ആ പേറ്റന്റിനെ ഇൻഫ്രിഞ്ച് ചെയ്യാണ്ട് നമുക്ക് അതിന് വർക്ക് ചെയ്യാൻ പറ്റില്ല വിത്ത് എ സ്ലൈറ്റ് മോഡിഫിക്കേഷൻ. സോ ഇറ്റ് ഇസ് ആൻ ഇൻഫ്രിഞ്ച്മെന്റ്. അതർവൈസ് if it is a totally new invention, no inventive concept, we can go for a patent.
ഈ ഒരു സംശയമുണ്ട്. നമ്മള് ഇങ്ങനെ കാറിന്റെ സീറ്റ് ബെൽറ്റുമായിട്ട് ബന്ധപ്പെട്ട് 3-point ഹാർനസ് എന്ന് പറഞ്ഞൊരു ടെക്നിക്ക് അത് വളരെ പോപ്പുലർ ആയത്, അത് കൊണ്ടുവന്നത് ശരിക്കും പറഞ്ഞാല് വോൾവോ ആണ്. അപ്പൊ അവരത് പേറ്റന്റ് ചെയ്തായിരുന്നു. അത് കഴിഞ്ഞിട്ട് പിന്നെ അവര് പേറ്റന്റ് അത് മാറ്റി, അതെ, പബ്ലിക് ആക്കിയത്. അത് എന്താണ് അതിന്റെ ഒരു സിഗ്നിഫിക്കൻസ്? എവിടെയാണ് നമ്മൾ അത്രയും ഇമ്പോർട്ടൻസ് വരുന്ന, നമ്മൾ എങ്ങനെയാണത് അങ്ങനെ തീരുമാനിക്കുന്നത്? എങ്ങനെയാണ്
അത് ആക്ച്വലി നമ്മള് ആക്സസ് ടു ഹെൽത്ത് എന്നൊരു കൺസെപ്റ്റ് ഉണ്ട്. ആക്സസ് ടു ഹെൽത്ത് എന്ന് പറയുന്നത് ഇറ്റ്സ് എ റൈറ്റ് ആണ്, നമ്മുടെ അവകാശമാണ്. സോ വോൾവോ കമ്പനി ചെയ്തെന്ന് വെച്ചാൽ ഇറ്റ്സ് എ ബ്രേക്ക് ത്രൂ ഇൻവെൻഷൻ. ആ ഒരു 3 harness ബെൽറ്റ് എന്ന് പറയുന്നത് ബ്രേക്ക് ത്രൂ ഇൻവെൻഷൻ ആയിരുന്നു. ബട്ട് ഇറ്റ്സ് ഫോർ ഇഫ് ദേ ആർ പ്രൊട്ടക്ടിങ് ദാറ്റ് ഇൻവെൻഷൻ and they are pursuing that invention with patent protection, what will happen? നമുക്ക് ആർക്കും ബാക്കിയുള്ള കമ്പനീസ് ഉള്ളത് ആ ടെക്നോളജി യൂസ് ചെയ്യാൻ പറ്റില്ല. അത് ആൾക്കാരുടെ ലൈഫ് സേവിങ് ആയിട്ടുള്ള ഒരു ഇൻവെൻഷൻ ആയിരുന്നു. അതുകൊണ്ടാണ് വോൾവോ അതിന്റെ റൈറ്റ് വേണ്ടെന്ന് വെച്ചത്. ഇപ്പൊ നമ്മുടെ കോവിഡ് സിറ്റുവേഷന്റെ കേസിൽ എന്താ സംഭവിച്ചത്? നമുക്ക് ഇന്ത്യയിലെ എല്ലാ ഫെസിലിറ്റീസും ഉണ്ട്. വി ഹാവ് ഓൾ ദ ഫെസിലിറ്റി ടു മേക്ക് ഓൾ ദ ഡ്രഗ്സ് ബിക്കോസ് വി ആർ ദ ഫാർമസി ഓഫ് ദ ഡെവലപ്പിംഗ് നേഷൻ. നമ്മളാണ് ആക്ച്വലി എല്ലാ രാജ്യത്തേക്കും മരുന്ന് കയറ്റി അയക്കുന്ന കൺട്രി. സോ വി ഹാവ് ദ ഫെസിലിറ്റി ബട്ട് വി ഡോണ്ട് ഹാവ് ദ പേറ്റന്റ് റൈറ്റ് ടു മേക്ക് ദ മെഡിസിൻ. സോ വാട്ട് ഇന്ത്യ ഡിഡ് ദാറ്റ്, ഇന്ത്യ ആൻഡ് സൗത്ത് ആഫ്രിക്ക, ഇന്ത്യയും സൗത്ത് ആഫ്രിക്കയും പിന്നെ ബാക്കിയുള്ള ഒരു 150 കൺട്രീസും കൂടെ ചേർന്ന് 120 കൺട്രീസും ചേർന്നിട്ട് അവരൊരു പ്രപ്പോസൽ ഉണ്ടാക്കി. ബിക്കോസ് റൈറ്റ് ടു ഹെൽത്ത് എന്ന് പറയുന്നത് ഒരാളുടെ ഫണ്ടമെന്റൽ റൈറ്റ് ആണ്. അപ്പോൾ ഫണ്ടമെന്റൽ റൈറ്റിനെ വയലേറ്റ് ചെയ്യുന്ന ഒരു സാധനങ്ങളും നടക്കാൻ പാടില്ല. അപ്പൊ നമുക്ക് റൈറ്റ് ടു ഹെൽത്ത് എന്ന് പറയുന്നത് നമ്മുടെ ഈ ഒരു കോവിഡ് പാൻഡമിക് സിറ്റുവേഷനിൽ, അതേസമയം ഇൻവെന്റേഴ്സിനെ നമുക്ക് പ്രൊട്ടക്ട് ചെയ്യാതിരിക്കാനും പറ്റത്തില്ല. ഒരു ഇൻസെന്റീവ് വേണം അവർക്ക്. ഇൻവെന്റേഴ്സിന് ഒരു ഇൻസെന്റീവ് ഇല്ലാണ്ട് അവർ വർക്ക് ചെയ്യുമോ? വെറുതെ ഒരാൾ ഇൻവെൻഷൻ തരുമോ? ഇല്ല. അപ്പം ഇന്ത്യ പ്രപ്പോസ് ചെയ്തത് ഒരു പാൻഡമിക് സിറ്റുവേഷനിൽ ഒരു പർട്ടിക്കുലർ പീരീഡ് ഓഫ് ടൈമിൽ, പാൻഡമിക് എൻഡ് ചെയ്യുന്നവരെ നമുക്ക് പേറ്റന്റ് റൈറ്റ്സ് അല്ലെങ്കിൽ IP റൈറ്റ്സിനെ ലിഫ്റ്റ് ചെയ്യാൻ, റൈറ്റ്സ് ഒഴിവാക്കി തരാൻ പറഞ്ഞു. പക്ഷെ അതിന്റെ ലിറ്റിഗേഷൻ ഇപ്പോഴും നടന്നുകൊണ്ടിരിക്കുക, ഒന്നും നടന്നിട്ടില്ല. നമ്മുടെ കോവിഡ് തീരാറായി, എന്നിട്ട് നമുക്ക് അതിന് കിട്ടിയിട്ടില്ല റൈറ്റ്സ്. അപ്പൊ അത് എപ്പോഴാണ് തീരുമാനിക്കേണ്ടതെന്ന് വെച്ചാൽ ഓരോരുത്തരുടെ എന്താ പറയാ ആൾക്കാരുടെ മൈൻഡ് പോലെ ഇരിക്കും. ഇപ്പൊ വോൾവോ അത് അങ്ങനെ തീരുമാനിച്ചെന്ന് വെച്ചാൽ അവർക്കറിയാം അത്രയും ഇമ്പോർട്ടന്റ് ഇൻവെൻഷൻ ആണ്. നമ്മളത് പ്രൊട്ടക്ട് ചെയ്ത് വെച്ചാൽ ഒരുപാട് ആൾക്കാർക്ക് അത് യൂസ് ചെയ്യാൻ പറ്റാണ്ട് വരും. അതുപോലെ തന്നെയാണ് മരുന്നിന്റെ കേസിലും. നമ്മുടെ ഇന്ത്യയിൽ മരുന്നിന്റെ കേസിൽ സംഭവിക്കുന്നതെന്ന് വെച്ചാൽ നമുക്കൊരു ക്യാൻസർ ഡ്രഗ് ഉണ്ടായിരുന്നു. ആ ഡ്രഗിന് ഇവിടെ ഫസ്റ്റ് ലിവർ ക്യാൻസറിന് ഒരു ഡ്രഗാണ് അത്, നെക്സവർ എന്ന ഡ്രഗ്. അത് ഇവിടെ ഇൻട്രൊഡ്യൂസ് ചെയ്ത സമയത്ത് പേറ്റന്റ് റൈറ്റ് ഉള്ള സമയത്ത് അതിന്റെ പ്രൈസ് എന്ന് പറയുന്നത് ഒരു കോഴ്സ് ഓഫ് ട്രീറ്റ്മെന്റ് 2,80,000 rupees ആയിരുന്നു. അപ്പൊ അത് ആ ഒരു റൈറ്റ് നമുക്ക് പേറ്റന്റ് റൈറ്റ് ഉള്ളതുകൊണ്ടാണ് ആ ഒരു പ്രശ്നം ഉണ്ടായത്. അപ്പം ഇന്ത്യയിൽ നമുക്കൊരു പ്രൊവിഷൻ ഉണ്ട് കമ്പൽസറി ലൈസൻസിങ് എന്ന് വെച്ചിട്ട്. അപ്പം കമ്പനീസ് ഇതിന്റെ റൈറ്റ് നമുക്ക് തന്നില്ല എങ്കിൽ നമുക്ക് കമ്പൽസറി ലൈസൻസ് പ്രൊവിഷൻ വെച്ചിട്ട് നമുക്ക് അതിനെ റൈറ്റ് എടുക്കാം. പക്ഷെ അൺഫോർച്ചുനേറ്റ്ലി നമുക്ക് ഒറ്റ തവണ അത് ചെയ്യാൻ പറ്റിയിട്ടുള്ളൂ, 2012 ഐ തിങ്ക്. അതിൽ ആ ഒരു വർഷം ഒരു കമ്പൽസറി ലൈസൻസ് നമുക്ക് ഗ്രാൻഡ് ചെയ്തിട്ടുണ്ട്. അതിനുശേഷം നമുക്ക് ഒരു കമ്പൽസറി ലൈസൻസും ഇല്ല. കാരണം ഇന്ത്യ അത് ചെയ്യില്ല. കാരണം പല മൾട്ടിനാഷണൽ കമ്പനീസ് ആയിട്ടുള്ള എഗ്രിമെന്റ് ആണ്. നിങ്ങൾക്ക് നോക്കിയാൽ തന്നെ അറിയാം, നമ്മുടെ പ്രൈം മിനിസ്റ്റർ ഒരു കോൺഫറൻസിൽ അത് വളരെ പബ്ലിക്കായിട്ട് പറയുകയും ചെയ്തു, നോ മോർ കമ്പൽസറി ലൈസൻസിങ് എന്ന് പറഞ്ഞിട്ടുണ്ട്. അപ്പൊ കമ്പൽസറി ലൈസൻസ് പോയി കഴിഞ്ഞാൽ എന്താ പറ്റുന്നത് വെച്ചാൽ ഈ ഫാർമസ്യൂട്ടിക്കൽ കമ്പനീസിന്റെ മൊണോപ്പൊളി നടക്കില്ല. നമ്മൾ ചെറിയ പൈസക്ക് ഈ ആക്ച്വലി ആ കേസ് സംഭവിച്ചത് 2,80,000 rupees ഡ്രഗിന് അവർ 8,000 rupees അവർ പ്രൊവൈഡ് ചെയ്തു. അടുത്ത മറ്റേ എന്താ പറയാ ബെയറിന്റെ ഡ്രഗ് ആയിരുന്നു. ആക്ച്വലി നാറ്റ്കോ അത് അപ്രോച്ച് ചെയ്ത നാറ്റ്കോ അതിനെ 8,000 rupees പ്രൊവൈഡ് ചെയ്തു. ബട്ട് നമ്മളൊരു റോയൽറ്റി ബെയറിന് കൊടുക്കുകയും വേണം. ആ ഒരു പ്രൊവിഷൻ ഉണ്ടായിരുന്നു നമുക്ക്. പക്ഷെ ഇപ്പൊ അത് ഒന്നും ചെയ്യുന്നില്ല. അപ്പൊ ഈ ഈവൻ കോവിഡ് സിറ്റുവേഷനിൽ പോലും അത് ചെയ്തിട്ടില്ല. അപ്പം സംഭവിക്കുന്ന വെച്ചാൽ നമ്മളെപ്പോഴും അത് ഓരോരുത്തരുടെ തീരുമാനമാണെന്ന് ഞാൻ പറയും.
ഓക്കെ, എനി മോർ ക്വസ്റ്റ്യൻസ്? ആർക്കെങ്കിലും സംശയങ്ങൾ ഉണ്ടെങ്കിൽ, പേറ്റന്റ് വളരെ ഇമ്പോർട്ടൻ്റ് ആയിട്ടുള്ള ഒരു ടൂളാണ്. നിങ്ങൾക്ക് ആർക്കെങ്കിലും എന്തെങ്കിലും തരത്തിൽ ഇൻവെൻഷൻസ് ഉണ്ടെങ്കിൽ തീർച്ചയായിട്ടും ഉപയോഗിക്കാവുന്നതാണെന്ന് മനസ്സിലായി കാണും. എന്തെങ്കിലും സംശയങ്ങളൊക്കെ ഉണ്ടെങ്കിൽ നിങ്ങൾ ചോദിക്കാനുള്ള ടൈമാണ്.
ഈ മെയിൽ ഐഡിയിൽ 2 മെയിൽ ഐഡി ഉണ്ട്.
ഓക്കെ,
എന്തെങ്കിലും സംശയം ഉണ്ടെങ്കിൽ അത് ചോദിക്കാം. 2 ഫോൺ നമ്പർ ഉണ്ട്. എന്തെങ്കിലും IP റിലേറ്റഡ് ക്വറീസ് ഉണ്ടെങ്കിൽ നിങ്ങൾക്ക് അതിൽ ചോദിക്കാം. So actually me and Dr. Ritesh, we both are working in IP facilitation cell of IIC APRS. So he is an assistant professor there and I'm working as a research officer there. So we are actually facilitating the patent filing. So you can approach us for any patent related queries and patent filing, everything.
Okay.
So I believe there is no more questions. So thank you all. So patiently hearing me.
ഓക്കെ, അപ്പോൾ നമ്മൾ നമുക്ക് വളരെ ഒരു പവർ പാക്ക് ആയിട്ടുള്ള ഒരു സെഷൻ ആയിരുന്നു, IPA കുറിച്ചും പേറ്റന്റിനെ കുറിച്ചും എല്ലാം. അപ്പൊ അത് നമ്മൾക്ക് അറിവുകൾ പകർന്നു തന്നതിന് മാഡത്തിന് നന്ദി പറയുന്നു. എല്ലാവരും ലിങ്ക് ഫോർ അസസ്മെന്റ് ആൻഡ് ഫീഡ്ബാക്ക് ഒന്ന് ഫില്ല് ചെയ്യുക. യുവർ സർട്ടിഫിക്കറ്റ്സ് വിൽ ബി ഇമെയിൽ ടു യു ആഫ്റ്റർ ഫില്ലിംഗ് ദാറ്റ് ഫീഡ്ബാക്സ്. ഓക്കെ മാഡം, താങ്ക് യു.
Thank you, sir.
ഓക്കെ.
So once again, thank you all.
എല്ലാവർക്കും ഒരിക്കൽ കൂടി താങ്ക് യു. നമ്മളുടെ ഫസ്റ്റ് ഡേ ഓഫ് ഇമ്പാക്ട് ലെക്ചേഴ്സ് കണ്ടതിന്. നമ്മളുടെ നെക്സ്റ്റ് ഡേ വിൽ ബി ഓൺ July 13th. നമുക്ക് അന്ന് മീറ്റ് ചെയ്യാം പുതിയ സെഷൻസുമായി. See you then.